Welcome back. At this point in the course, you may be thinking we're going through the protected classes under Title VII. We've covered race, color, sex, and national origin, and logically, we would take up religious discrimination next. But in fact, religious discrimination is very different from those other four protected classes. And therefore, I have that separated into the next module of the course. Meanwhile, we'll talk about age discrimination. Age discrimination is not a part of Title VII, but in terms of how a case is made and proved, it is very similar to Title VII. So it makes sense that we would raise this age issue now. Now, what's the setting? Well, we know that American culture values youth, that people who are young are valued much greater than those who are not young. If you go to California and you want to work in the tech industry, you have to be young in order to get a job. If you want to go to work at Google or Apple, you've got to be young, essentially. That there comes a time where you simply can't apply for an entry-level job because we believe young people are brighter and work harder and are more creative, and therefore, regardless of what the facts show, that's our internalized belief. Nevertheless, we know that by 2030, the number of workers who are 65 and over will double from what it is now. People are going to live longer. People have extended lives. 65 used to be, in your sunset years. 65 now, you may have another 25, 30 years of productivity. So we're going to see a lot more older workers in the coming decades. And incorporating these older workers is going to be a challenge for employers if they have a business model built around the idea of older workers leave and younger workers come in their place. If the older workers don't leave, it can be more difficult for an employer to figure out how to address this problem without resorting to unlawful discrimination. So I think, personally, age discrimination is going to be a next major area of conflict just because we're going to have so many, as the baby boomers age, so many people that are pushed into that category of being 60 plus and yet still needing to work, needing a job. So in this lecture, we're going to look at the Age Discrimination in Employment Act. The ADEA regulates age discrimination. So for your test purposes, no, Title VII doesn't regulate age discrimination, only the ADEA. And the ADEA was passed back in 1967 by Congress, and the statute was designed to promote the employment of older persons on the basis of ability. This is a key distinguishing factor between Title VII and the ADEA. Title VII, remember, is completely agnostic. It protects blacks and whites, it protects men and women, it protects Czech Americans and Mexican Americans. The ADA, however, only protects older persons against discrimination in favor of younger persons. Now, the law forbids discrimination when it comes to any aspect of employment, and age discrimination occurs when an applicant or an employee is treated less favorably because of their age, and age being older age. Now, it doesn't have quite the same widespread effect as Title VII. Title VII applied to employers with more than 15 employees. Well, in order to be subject to the ADEA, you have to have more than 20 employees. And the Act protects people who are 40 years old or older from discrimination. So in order to make an ADEA claim, you must be over 40. They must be over 40. It does not protect workers under the age of 40. So if you are a 38-year-old who loses a job and are replaced by a 28-year-old, you don't have a claim because you're not over 40. So ADEA only applies to workers and applicants who are over the age of 40. There's no claim for reverse discrimination under the ADEA. You cannot bring a claim that someone older than you is getting treated more favorably. Even if you are both over the age of 40. If you're 42 and you are rejected for a job and a 48-year-old was hired, you don't have a claim. There's no bidirectional purpose that the discrimination must be against an older person in favor of a younger person, and not vice versa. Now, it's not illegal for an employer to favor an older worker over a younger one. This is simply not an aspect of the law. You may think it should be the law, but it's not the law. Discrimination can occur even though the victim and the person who discriminated against the victim are both over 40. So if in fact I was a 48-year-old and I lost a job to a 42-year-old, I would have a claim under the ADEA, even though technically myself and the other party are in the same protected class. It's much more difficult to recover under the ADA than under Title VII. Now we know that both statutes are enforced by the EEOC. They're both discrimination statutes enforced by the same agency. And they both provide private rights of action. But discrimination based on age is more difficult to establish than a Title VII claim, for the reasons we'll talk about. A claim under the ADEA, it requires intent. The purpose of the discriminatory act must have been to discriminate on the basis of age. Remember when we were talking about disparate impact in terms of race or sex or national origin? In those cases, if we had a screening device that was neutral on its face and there was no intent that it have this disproportionate impact, we may still be liable if in fact it does have that. For an ADEA claim, you must establish that the policy was put in place to discriminate against older people. And there is much greater latitude under the ADA for reasons for an adverse employment action than under Title VII. The ADA defendant is going to have an easier time overcoming the claims of the ADEA plaintiff than the same defendant would as opposed to a Title VII plaintiff.